Good afternoon to one and all. It gives me immense pleasure to welcome you all to this interactive session, Practical Aspects of Sports Law Dispute Resolution, organized by JSSLC Law College, Mysuru, under the IQAC initiative. Today's session is a valuable opportunity for us to understand an emerging and highly specialized field of law. Sports law is no longer a niche space, but rather a grown dynamic area into the legal practice of contracts, discipline, arbitration, governance, ethics, and international adjudication. As sports continue to expand as a professional and commercial sector, the role of international dispute resolution in this field has become increasingly important. We are privileged to have with us our distinguished resource person, Mr. Dhruv Siddharth, international sports consultant and ad hoc clerk, Court of Arbitration for Sports. We are truly grateful to have you with us, sir, taking out time in your busy schedule for guiding us through sports dispute arbitration in the practical aspects of law. Thank you, sir. We are truly grateful and for support by Professor K.S. Suresh, sir, Chief Executive, JSSLC Law College, Mysuru, and Dr. Vanishri, Principal Ma'am, for your unwavering support in helping us foster such academic initiatives. Thank you, ma'am. To our faculty coordinator, Josmin Thomas, sir, for his dedication, attention to details, and unwavering support in organizing these events. Thank you, sir. To formally commence today's program, I request Dr. N. Vanishri, Principal Ma'am, to kindly deliver the welcome address and introduce our distinguished resource person, Mr. Dhruv Siddharth.
A very good afternoon to one and all present here, especially to Mr. Dhruv Siddharth, who is here with us, the International Sports Consultant and ad hoc clerk at CAS, who is the resource person for this afternoon, and on a very pertinent topic. Now, before I would welcome him formally, I would like to give a brief profile about sir to the audience sitting here, the attendees and my beloved students. So, Mr. Dhruv Siddharth completed his LLB from the Zindal Global Law School in the year 2023 and subsequently pursued an LLM in International Sports Law from the ISDE, Madrid. His academic training has been complemented by a growing and impressive body of professional experience in the field of international sports law and dispute resolution. He is presently associated with the CRA, Coelho Ribeiro e Associates, CRA Law, Lisbon, Portugal, where he serves as an international sports consultant. In this role, he works on matters relating to sports arbitration and international sports law, while also advising international clients on cross-border legal issues. Prior to this, he worked with the same firm as a sports law paralegal under the guidance of Mr. Rui Botica Santos, a renowned CAS arbitrator, where he assisted in extensive legal research and in the drafting and organization of ongoing CAS appeals and awards. He also serves as an ad hoc clerk at the Court of Arbitration for Sports, Lucerne, Switzerland, where he assists and coordinates with various CAS panels in the drafting of CAS awards. Through his work, he has been involved in over 50 CAS cases, covering a wide range of disputes, including player transfers, sporting succession, contractual issues, and regulatory matters in football. His professional journey also includes experience as a sports legal intern in CRIDA Legal, where he worked on issues relating to anti-doping regulations, sports governance, online gaming regulations, sporting event organizations, and legal due diligence concerning national sports federations. In addition, he has worked with leading legal and dispute resolution practices such as MD&T partners and camp arbitration and mediation practice, gaining exposure to company law, arbitration, mediation, and legal research. With this diverse and impressive blend of academic training and professional experience in sports law, arbitration, and dispute resolution, including international legal practice, Mr. Dhruv Siddharth is exceptionally well placed to address us today on the theme practical aspects of sports dispute resolution. And we are all eagerly waiting to listen to you. A very warm welcome to you, sir, on behalf of the college and on my personal behalf.
Thank you so much. Thank you so much.
A very warm welcome to our beloved Chief Executive, Professor K.S. Suresh, in his absentia. The course coordinator, Mr. Josbin, teaching and non-teaching faculty, including the systems manager, Mr. Madhu Kumar, and my beloved attendees, the students, who are the central focal point of this particular great event. Make the most of it. And you can, I think, definitely the girls and the boys here are more into both indoor and outdoor sports, and plus the legal aspects. So you can definitely clear all your doubts with our great resource person. Once again, a warm welcome to one and all present here. Thank you very much.
Thank you, ma'am, for your warm and inspiring words. We welcome you too. Now we move to the most significant segment of today's program. I invite Mr. Dhruv sir to kindly address the gathering.
Can you guys hear me? Am I audible?
Excuse me, sir. Can you hear us?
I can hear you. Can you hear me?
Yes, sir. One second. Please excuse us for 1 minute, sir.
No problem. Take your time. No rush.
Sir, yes, sir. You can start now, sir.
All right. So let me just share my screen so that it makes it easier for everyone to see.
Sure, sure, sir. Thank you.
I hope it's visible.
Yes, sir, it's visible. Yes, sir, it is visible.
Okay, just can you let me know if it's on the full screen or not? Because I'm just trying to.
It's not in full screen
Yeah, I
anymore.
think.
Yeah, it is now.
I think it is. Oh, perfect. All right. First off, thank you so much for that introduction. I'm very, very honored to be here, and thank you, Mr. Jospin, and the whole faculty of JSS College for this invitation and for me to be present and to speak to all of you all and share whatever knowledge I have. And yeah, so like ma'am said, a smaller introduction is my name is Dhruv. I am a international sports consultant working in Lisbon, Portugal. and I'm also an ad hoc clerk for the Court of Arbitration for Sport, which is the short form is called the CAS. And you will hopefully by the end of the session you will know what it is and what we do, and yeah, this at least my focus for this session is to be more of the practical aspect, not just a lot so much academic. But I just hope you have a good time. I know most of you all are in the third year of law school, which is, let's say, the pinnacle of the 5 years. So I hope you're not having too much of a stressful time, and I hope you're still enjoying yourselves and having a good time. And yes, hopefully I do have some time at the end of our session to answer some questions. I have received some questions from Mr. Jospin, so thank you so much for that. And yeah, so today we shall see, like he said, the understanding the CAS code, which is the law book for the Court of Arbitration for Sport, and the functionings of what the practical aspects are, and how one was to admit an appeal or to file a case in front of the court. Yeah, so before we start, I just want to outline what we might learn. What the CAS is, what the Court of Arbitration is. When disputes go to CAS instead of the normal courts, why the CAS exists. A lot of people have this question as to why do we even need the CAS? So I'll explain why. How disputes reach the CAS, and how are cases actually conducted in practice, right? We'll also try to look at hearings, how are hearings conducted. We'll try to look at how the awards are conducted, how costs are divided, and in the end, sometimes awards or decisions can also be settled by the parties. So I'll explain how that can also go about in front of the CAS. And finally, we shall also see some common mistakes that lawyers tend to make in front of the CAS and how we can avoid that. So I hope to see all of you all once you finish your law school to also be there in front of the CAS. So I will try to give you a pinpoint of what all we can expect, right? So I hope everyone's comfortable, and yeah, we can start. So let's start with the basics. What exactly is the CAS? So the Court of Arbitration for Sport was founded in 1984, right? And their headquarters is in Lausanne, which is in Switzerland. So it was designed specifically to resolve disputes in international sport. So they deal with matters involving athletes, involving clubs, federations like the national federations like the AIF, which is the All India Football Federation. You also have the international federations, which are FIFA and the International Olympic Committee. So any dispute which arises there can also be handled with the CAS. And CAS has the sports jurisdiction to handle all these cases. Today, CAS handles more than 200 cases annually, particularly in football and even anti-doping matters, which is another thing we'll discuss further on. And CAS is often called the Supreme Court for sport because in the end, CAS has the final say. But again, one of the questions, like I mentioned, was why do we need a separate court for sport? A lot of my colleagues or even friends and even students do ask me this question, and I'll explain as to why we need it. So if you see, international sport is global. So you might have in the streets of Mysore, you have the IPL going on now, and I hope all of you are supporting Chennai Super Kings. You have to. Let's say you play cricket in the streets of Mysore, but you can play the same sport in the streets of, let's say, Birmingham or London, right? The sport is the same. It's just that the location is different. So what does that cause? So you have different legal systems, but the same sport. So that can cause some problems, right? We can cause problems like different legal frameworks, because if there is an issue, how does one deal it with in Chennai or how does one deal in London? You have inconsistent decisions. So the thing of, a court can take 2 years to handle a subject matter here, but a court in another country can handle it in 6 months. And also slower court proceedings. So that's where CAS comes into play. And they first provide a neutral arbitration and a neutral forum to establish how one can solve certain issues. Specialized expertise, where you have people trained to handle certain subjects in sports law, where it's not just a litigation lawyer or a criminal lawyer, a civil lawyer who might not have the expertise as to what understands and how they can go ahead solving certain problems. And also the code of arbitration, right? Arbitration is a much faster process than litigation. So sports issues tend to be solved in a much faster pace rather than you going to court and then filing appeals, and it takes a much longer time if you handle it in national courts. Because national courts not only handle everything else, but also will also have to handle sports. So that didn't make sense for a lot of people. So they created this specialized forum to handle specific sports matters, right? And yeah, so imagine I could even ask you guys a question, and maybe later on you could think about and answer it. Where let's say you have a Brazilian football club, and there is a Brazilian football club who has a dispute with a Spanish football club, and the dispute is regarding a Chinese football player. So you have Brazilian jurisdiction, Spanish jurisdiction, Chinese jurisdiction. How does the court decide which one to use? Right? It gets confusing. So that's why CAS solves it and says, no, you handle the FIFA regulations, which is, let's say, the football regulations. And any dispute, the CAS has its own regulations, which will be applied to everyone. So I think it makes it much easier. So now let's take a look at how CAS is structured. How does the CAS look from the inside? So here you have something called the ICAS. ICAS is like the administration of the CAS. So they are the ones who handle the nomination of the judges or the arbitrators, the correspondence. So that means you file certain things, you request emails. The ICAS takes care of that. So they also ensure the independence of the CAS. They make sure that the CAS is a sole separate body, does not have any conflict of interest. It helps, like I said, the appointment of arbitrators, and the proper function of the CAS is what it looks after. So when I say a panel, which I will explain a little further on as well, but just to give you a small taste, the panel can consist of either two things. You have one as a sole arbitrator. That means there's one judge who decides everything. Or you can have a panel of three arbitrators, where there's one as the president who will take the most important decisions. And then you have the co-arbitrators who help the president come up with their decisions, right? Here, not everyone can be a CAS arbitrator. So even here, they make sure that there are certain guidelines and certain guarantees that only certain people can become CAS arbitrators. Who are these people? One who have maybe 10 or 15 years experience in the legal field, who have some specialization in sports law, who have understood or worked in certain federations, or maybe helped in clubs, or they understand how the sports world works. And to get, you have to apply to the CAS. You might get selected and you are joined a list, you are part of a list. And then the administration, the ICAS, will then choose, okay, we choose this person to handle this case, we choose this person to handle that case. Or the parties can choose. When, let's say, I have a case in front of the CAS, I can choose, okay, I choose this arbitrator or Mr. X or Mr. Y to be my arbitrator. So that is how it's shown. So CAS makes it very unique and very strict to see that, okay, we take things very seriously and we want to make sure that the best is taken care of. And another small point I would like to add is, let's say I am an arbitrator, I work for the CAS and I'm a judge for a decision. But after a couple of years, I feel like I want to start representing clients, and I want to maybe represent certain football clubs or certain players in front of the CAS. So basically join the council of the player. This also has to be taken care of because I cannot do that so easily. I have to first inform the CAS saying, listen, I was an arbitrator, but now I choose to step down and join as a counsel for a particular party. And then they will remove my name from the list, and only then I can join. So it is very, they make it very, maybe slightly complicated, but they make it clear that there cannot be any conflict of interest and there cannot be any source of incompetence. And that is how the CAS is structured, right? So I hope you're following me. I hope I'm not talking too fast. And if there's anything, you can let Mr. Joshua know, and I can always answer your questions a little later on. And so now we shall see how the caste code, like I said, we consider this the Bible of our code, right? All the rules are mentioned in the caste code, and we have to handle how each and every procedure is taken care of from the caste code. So the caste code governs all caste proceedings, and you know they also have two set of provisions, right? You have the institutional provisions, which are, as I mentioned on the slides, which handle the structure and the administration of the caste. And then you have the procedural, which is where we will talk about more. These are the rules which govern the arbitrations. So this defines like the jurisdiction, how a person should file, certain evidences, how to collect and submit evidence, how are the awards supposed to be drafted, how are the hearings supposed to be conducted, everything the caste code defines. And these are the procedural rules, right? So this is how it will be structured. So you have the book, and it's the first part is the institution is to handle, okay, the structure, who's the president, who's this, who's that, and then you have the procedure. So one of the first questions, again, when a person is looking to file in front of the caste, they always have to ask, and students remember this, that you always have to first check whether the caste has jurisdiction. So the caste should be able to have the competence and the authority to rule on a certain case. So the first thing we always check is whether I can first send this case to caste or not. And that is what the next slide is about, the scope of the caste jurisdiction. So this is taken care of in Article 27. And I can even forward the caste code to Mr. Josman, and he can send it to you. So you can maybe later on check out and see, understand how the caste code is drafted. So under this, caste can only have jurisdiction if three things happen. One, if there is an arbitration agreement existing. So if I have a case, let's say I'm a Brazilian club and I have another Spanish club, let's say, in any decision or any contractual agreement we have between ourselves, the contract has to state that if any dispute was to arise, the caste has jurisdiction to handle that dispute. If that clause is there, perfect, caste has jurisdiction. The others, if the parties agree, let's say I have a dispute with Mr. Joshua, let's say, but we speak and we decide, okay, I think let's go to caste and handle it amongst ourselves. And then if both the parties agree that caste has jurisdiction, then caste has jurisdiction. The third thing is the sports regulations. So you have the FIFA statutes or the UEFA statutes, Olympic Charter, which handle the Olympic Games. All these also mention that if any dispute were to arise between parties within this tournament or within this organization, caste will take care of it. So when the rule books allocate caste to handle certain matters, caste automatically gets jurisdiction, right? There was another very important case which has happened recently called the RFC Serine case, where caste confirmed that they have jurisdiction even though the parties claimed that they might not have. This shows that, very often, even when you participate in tournaments and participate in FIFA organized tournaments or, Olympic tournaments, you implicitly agree that if any dispute was to arise, that just by participating in this tournament, I give my consent that caste has jurisdiction, right? Okay. So now that we have a slight understanding of what the caste is, what it's about, how it's structured, and how one can allocate a jurisdiction to the caste, we shall see the next thing, that there are two types of caste proceedings. So you have the ordinary arbitration and the appeal arbitration. So ordinary arbitration is a very, maybe not so common part of the caste, but still very important. And here it is used for mostly contractual disputes, right? You have things like sponsorship agreements or any disputes against agencies or even employment disputes can be handled by the ordinary style of arbitration. What does this mean? This means that, like I mentioned, if I have a contract and in the contract it states that Any dispute, you can go to CAS. Then I have to file a request in front of CAS saying, listen, I have a dispute. I want to file in front of CAS and start the arbitration procedure. That is the ordinary. I will explain a little later on. But the second aspect, which is more important and more common in CAS, is the appeal arbitration procedure. Appeal makes the CAS become the Supreme Court for sport, right? So this happens when, let's say, FIFA issues you a decision that you don't like, right? They say you cannot play for another 6 months because you have violated certain agreement. That's when you can appeal to the CAS and say, listen, I do not agree with this decision and I want to challenge this decision. And that's where CAS falls. So you have FIFA disciplinary sanctions, eligibility decisions, doping sanctions. Let's say the VADA code, where they have held you that you have violated some agreement, you can challenge that. So usually appeals regards challenge. And most of the cases are appeals in front of the CAS. Okay. And so now that you've understood these are the two things, I will jump into what ordinary arbitration procedures. Fairly simple, right? Like I said, now if I find out that I have an issue and I want to take it to CAS, I first check that this is the party I have an issue with. Whether me and let's say, I'm sorry to always bring Mr. Jospin like this, but let's say I have a dispute with Mr. Jospin and I say, okay, first I see the contract between me and Mr. Jospin, whether the contract is mentioned that CAS has the jurisdiction to handle it. So then I file a request for arbitration in front of the CAS. Once I do this, I pay a court fee and I say, okay, I've paid the fees and now please start the procedure. So once the CAS is satisfied that there exists an arbitration, that I've paid the money to start the proceedings, they will then notify Mr. Jospin and say, okay, you have a case pending in front of you. Please submit ABC. It is, like I said, commercial disputes, and it is very similar to commercial arbitration. Fairly straightforward. And once the request is sent, Mr. Jospin sends his response to what he feels is true. We have written submissions. Then the CAS then decides who is the judge and who is the panel to decide the case. And then we have the hearing if necessary. Sometimes hearings are not necessary if the case is fairly straightforward. And then after that, the award is being drafted. Now, we shall see how, before we reach an appeal, how does the FIFA case travel? Let's see. So you have a player, let's say an Ecuadorian player who has a problem. And then he has his club who first says, no, you have not performed your duty well. Or let's say the Ecuadorian player says, you have not paid my salaries for 3 months. And the rule says that for 3 months, if you don't pay salary, the player has the right to file a case against you. So let's say the player feels that for 3 months, I have not got my salary, I'm filing a case. So he files it first in front of FIFA. So the FIFA takes it and then tries to decide the case. So now let's say FIFA takes it and says, no, the club is right, the player is wrong. And they issue a decision against the player saying, no, you do not, you have no right to claim your salary. You have not fulfilled A, B, C, D. So you are actually have no right to claim your salary. Then the player has two options. Either he can appeal to the FIFA appeal committee or he takes it straight to CAS. Let's say he takes it straight to CAS. He takes it to CAS, and that's where the appeal procedure starts. So now let's say the player has said, no, I don't agree with this. And he files in front of CAS. And let's see how that happens. So now you have the appeal arbitration. So this is handled between Rule 47 to Rule 59 of the CAS code, right? So first off, we have 3 main documents. And this is where it gets interesting. I hope if you feel like you want to take notes, feel free, or else I will send this this PowerPoint to Mr. Jospin. You can always use it as a reference. 3 main documents. One, you have the statement of appeal, right? This is where the case begins. So you have, this is where the player has to file in front of the CAS and say, this is the issue I have. This is the problem I have against the club, and I have to file a case. So the document in the statement of appeal must have the decision appealed against. So the FIFA decision which has been decided. You say this is the decision I'm appealing against. So you send that to the CAS. The parties involved. Who are the parties involved? The request for relief. This is what you are asking the CAS to dispute. The nomination of the arbitrator. Usually the appellant here can decide who they want the arbitrator to be. So they can choose, say, I want this person to be arbitrator. The same, the respondent would also say, I want this person. And then the CAS will decide whether they choose one or they make it into a 3-person panel. And yeah, so this is the documents. You file it, you sit with your lawyer, and as a player, you file your documents. But then what you need to see is that the time limits are very, very important. So here you are given 21 days from the time you receive the notification of the appealed decision. So let's say I'm FIFA. I send the decision to Mr. Jospin and say, this is the decision. If you want to appeal, you have 21 days from today, from the day you receive the decision. Then Mr. Jospin has to see, okay, he has to get all the documents, take care of the nomination of the arbitrator, prepare his documents, and within 21 days, submit his statement of appeal to the CAS. Okay, these 21 days are very important, right? Because CAS is very strict with their deadlines, and deadlines can, a lot of lawyers tend to try to say, oh no, we have this extension or this was a problem. Unfortunately, we don't accept that unless you have an exceptional circumstance and you were to email the CAS well in advance and say, listen, I have in 20 days, I have to submit the statement of appeal, but due to A, B, C, D reasons, I cannot do it. Please grant me an extension. Then they might be able to accommodate you, but not in the last minute, definitely. So now you file the statement of appeal, right? You have sent it. It's well within the time limits of 21 days. And then we shall see what comes next. Next is the appeal brief. This is a more detailed version of your statement of appeal, right? Because the statement of appeal is just the facts. You give a base understanding to the CAS saying, this is the issue, these are the parties, this is what I want from you, and you send it. Appeal brief is a more detailed and more defined way of stating your arguments. Here you have 10 days from the time you submit your statement of appeal to submit your appeal brief. Your appeal brief must contain your full legal arguments, any evidence you might have, any witness statements if you plan on calling certain witnesses or experts to come and talk. You have to name them and you have to provide certain documents on behalf of them. And all this guarantees you have to do it in 10 days, right? This also is a very strict deadline. But in a practical aspect, I will tell you, and CAS does usually allow a little bit more relaxed deadline for these 10 days. So what happens? Like, you will see this, hopefully all of you will also become sports lawyers, but you will see that the moment the statement of appeal is filed by a party, they will send an email which says, okay, we have a lot of matters to handle, we have other issues to take care of. Please grant us an additional 10 more days for the appeal brief. So the appeal brief, the CAS is more lenient and they say, okay, we grant you another 10 days. So that is something you can remember. And a lot of people, do this to get extra time and to make sure that the appeal brief is perfect, because this is the most important document for the appellant, right? For the person who is filing the appeal. So they have to make sure that all these documents are proper, perfect, and precise. So then you have this. So let's say you are very competent lawyers, right? You are very smart and you don't need an extension and you say, I will submit it in 10 days. You finish the submission and now it's time for you to maybe relax a little bit, because once you finish submitting your appeal brief, the onus falls onto the respondent who is responding to the case. And let's say I'm going to use Mr. Jospin as always. So let's say now it's Mr. Jospin's turn to respond as to see what the issue is. And this is called the answer or the respondent's written submissions. Here you have 20 days is given to Mr. Jospin to file his answer from the time he received the appeal brief. So the moment he received the appeal brief, 20 days starts for him to do it. Here, he has to include his defense arguments, again, same, his evidence, his witness experts, more or less has to mirror what the appeal brief says. And he has to challenge that whatever argument I say, he has to challenge and say that is wrong, and this is the truth, right? So, like I mentioned, time limit is still strict for this. And you have to understand that because this is an international aspect, an international law, public holidays are always counted as the time limit. You cannot say, unfortunately, I would like to say this, but you cannot say it's Diwali at home, it's a public holiday here, I cannot submit, doesn't happen because they don't celebrate Diwali in Lausanne. So you need to make sure that public holidays are always counted. Even Saturdays and Sundays are counted within the time limits. The only thing that you have to know is that if your submission date falls on a Saturday or a Sunday, it automatically gets pushed to the next working day. I hope you understand. So let's say I have to submit in 20 days, I'm working, and then on my 20th day, which I have to submit, is on a Sunday. It automatically gets pushed onto a Monday, and I submit it on Monday. So that's the only leeway. Otherwise, every other date is counted. So always remember, public holidays are not counted. Make sure your jurisdiction, in the sense the time difference, is also sometimes taken care of. You have to make sure that if it's 12 o'clock in Lausanne and it's already switched to the next day, you have to make sure you've sent it before it switches to the next day. And these are the things which are important to look at, and a lot of lawyers tend to forget and overlook this. But these, if you concentrate on this, I'm telling you, it makes you a more knowledgeable and more understanding of how these procedures work. Right? So now the documentation stage is done. The appellant has submitted a statement of appeal, his appeal brief. The respondent has submitted his answer. Now what happens? Now what happens is it comes to us. So let's say I'm the CAS. Now we have the documents. The arbitrators have been decided, and then the file has been submitted to the arbitrator for him to study. We shall go through the case. We will have some time to understand the case, what are the issues, what are the facts, and we shall come up with a decision of whether a hearing is necessary or not. So we shall ask the parties, okay, what does the appellant want? Does he want a hearing? He might say yes or no. Does the respondent want? He might say yes or no. So let's say both the parties say, we would like a hearing. And that is what we shall discuss. What exactly a CAS hearing might look like. So this is a rough diagram, and in the next slide, I will show you how it actually looks in real life. But this is a rough diagram to, let's say there's a panel of 3 arbitrators. The president sits in the middle. You have the co-arbitrators to his side. And then the table is usually in a circular form. So on each side, counsel and lawyers, you have the respondents and their counsel and lawyers, and any witnesses or experts they might bring to the hearing. And then at the end of the table, you have someone called the CAS counsel. So the CAS counsel is the admin of the hearing. So he handles make sure everybody's on time. The hearing starts on time. If, let's say, if somebody needs to present, he takes care of the PPT and the connections and the Wi-Fi, and he's the guy who runs and makes sure the procedure of the hearing is all taken care of. Right? Here is another important thing, if you can see under the PPT, is called the de novo review. What does this mean? It might sound very confusing, I understand. But de novo is Latin for a fresh perspective or a new, viewing something with a new lens. So this is something unique that the CAS has, is that even though, let's say, FIFA, as an appealed decision, FIFA has made a decision and sent it to the CAS, right? The CAS has the authority and the power to decide the case all over again, if he feels like it. If it sees and says, okay, maybe FIFA has not done a good job, or the CAS wants to understand the issue much better, it can decide this case all over again from the beginning, right? And that is what a lot of parties want. Let's say I'm not happy with what FIFA did. So I will go to CAS and say, you have the power to review this case from the scratch and start it from the beginning. And the CAS can accept or deny, but it has the power to do it. And this is what it does. Panels are allowed to re-examine the case entirely, and This is what we say as a de novo review. Now the hearing has started. Let's see how the hearing flow, how does that happen, right? And when I'm explaining this, I'll show you the picture of how the hearing is, right? And it has very nice views. So I hope someday you can go and visit it. And like I said, at the end of on the table, just behind the mirror is where the panel sits. And then on each side, you have the respondent and the appellant. So once everybody is seated, the president starts and says, welcome, and he introduces each of the parties, and he opens the floor for the hearing. So he grants, and again, you need to understand, hearings there are hearings which have gone on for a long duration when it's complex, and the case there's a lot of witnesses to talk about. But usually they are very strict on a timeline, right? Most of the hearings are around 2 to 3 hours long, but I've attended some hearings which have gone 6, 7, even 8 hours long, right? Because there are so many things to discuss. But before the hearing starts, the president sort of gives you an outline as to how much time is allocated to each party. So he says, the appellants are given 10 minutes to state their opening statements. So they come and they talk as to what they say, what the case is about. Then the respondents have their opening statements. Then the appellant again has a rebuttal and they can argue. The respondent again is also given a chance to speak. And then after that, they have the floor is given to the witnesses if the witnesses have anything to say. And during this time, the judges or the arbitration panel has the authority to question the witnesses, to ask them any questions they have, any doubts they have. And at the end of it, the appellant has 5 minutes of a closing statement. The respondent has 5 minutes to close his arguments. And then the panel takes charge and says, okay, we thank you for attending the hearing. And he makes sure that under Swiss law, because Swiss law is also applicable with the case, under Swiss law, you guys have had the right to be heard. This right to be heard is very important. So they first ask the parties if their right to be heard has been validated. And once they give their consent, he closes the hearing and says that within 3-4 months, we shall issue an award and a decision. And the panel there is closed. So this is how it happens. So even in the CAS code, the arbitration panel or the award is given 4 months to be drafted, not more, not less. And if there are again exceptional circumstances, you can request the CAS to extend and because we need more time to draft and etc. But usually within 4 months, we come up with a decision and we are issued it to the CAS, and then the CAS notifies it to the parties, right? So now I want to show you from my side because this is now where my work starts. Because I work for an arbitrator also, and as an ad hoc clerk, we are designed and designated to draft the award and to sit with the panel and help them come up with the ideas and the language and to come up with the structure of the award. And this is what I want to show you now. What is the structure? So first off, a typical structure has these many sections. You have the introduction, right? What the case is about, a little bit. You have the parties, who the parties are, where are they from, the factual background. And this is factual meaning not disputed. What do I mean by that? So let's say you might have certain facts that you think is true. I might have certain facts that I think is true. The panel's job is to see both and compare and see, okay, these are the facts which both agree on. And that is what will be mentioned in the award. Something that we can both agree. Proceedings before the CAS, what are the procedures happened when the dates were allocated for the hearing, what the witnesses said at the hearing, etc., etc. What has happened in the hearing, that is also mentioned in the award. Then you have the party submissions. These are what your appeal brief states and what the respondent's answer states. So this we will study, and we will not, because sometimes the appeal briefs and respondents' answers are very big, right? They're 30, 40 pages long, unnecessary sometimes. So it's our job to analyze those submissions and arguments and concise them. Make the only important arguments present in the award. And that is what we will summarize. Then we have the jurisdiction, admissibility, and applicable law. So jurisdiction, whether we state that CAS does have jurisdiction under this rule and this rule. admissibility, whether all the time limits have been properly fulfilled. So that if it has, then we say the case is admissible in court. And applicable law. This is what the parties have agreed on, what law should be used. Most will say if it's a FIFA issue, they will say FIFA regulations have to be used. If it's another issue, they will have to choose that which regulations have to be utilized to decide this case. And that is also will be stated. Once those have been stated, we enter the merits or what the case is decided on. And that is where we have most of our work. If we have a panel of 3 judges, we sit with them and we discuss what they think the case is, what we think the case is, and it is up to the president of the panel to draft the award, right? That is his main job. So he takes input from everyone and then he will write the case. Once he comes up with his decision, he sends it over to his co-arbitrators. They will check and say, okay, we agree with this point, maybe we change this point. And in those 3 months or 4 months, this is what happens. There is correspondence. We confirm and agree with the decision we make. And once we finalize it, we send it to the CAS for them to also finalize and send out the award. Right. So the operative part, which is the last part, is the decision. What we have decided in one page, we have to stipulate that Mr. Jospin is found not guilty of ABCD and he has to receive ABCD as his remuneration. That will be decided with the operator. And then the cost is what I will also explain a little later on, is what each party is allocated for, like how much they have spent during the award, how much they spent it traveling, etc., etc. All that will also be taken into consideration. So this is what we have for the CAS award, right? Now we shall see how the costs are divided. So you have arbitration costs, that is the costs for nominating the judge, because the judges do often get paid as well. So that is what is taken care of in the arbitration costs. You have the legal costs, which is your lawyer's fees, everything to be taken care of, all that the parties add on and give you a stipulated cost. You have the travel and accommodation. So let's say you have to travel to Lausanne to attend the hearing. You have accommodation. So all that is also accounted for and provided as a cost that each party will require. And any other miscellaneous expenses like expert costs, you have called witnesses, etc. So how does this bit decided is that each party decides an amount saying, for all this, we require 10,000 rupees, let's say, as our costs. The other party says another amount, right? Then it's up to the panel to decide whoever wins the case or whoever makes it more favorable, their awards will be allocated accordingly. And this, the panel can decide by itself. It has the authority to decide. And this is what something called a contribution. A contribution is, let's say Mr. Jospin has now finally won his case. The panel will decide, okay, Mr. Dhruv is found guilty of doing ABCD and he has to pay a contribution to Mr. Jospin for his legal fees, his arbitration fees, his travel fees. And that is my payment to him, because if I have lost the case, I have to satisfy Mr. Jospin's financial needs and I will pay that. And that's what happens. And this is all decided at the end when the panel has decided who has finally won the case. But not all cases have, it's so clear cut, where it's either Mr. Jospin or Mr. Dhruv. It doesn't always have to be that way. And this is where settlement can also come into play at the CAS. CAS encourages settlement because they want people, and like I said, they do not want arguments. They do not really want you to fight. They would like you to settle the case if it's possible. And during the case, if the panel or the judges feel that this issue can be decided amicably, they will try to push the parties towards each other and say, listen, there are things which you can give, maybe not. Why don't you look at settlement? We cannot ask them to decide, okay? We will only push them in the right direction. And if, let's say, Mr. Jospin and I speak to each other and decide, okay, let's not fight, we can come to a settlement. The CAS then suspends the proceedings and say, okay, the parties have reached a settlement. And the CAS has to issue an award only on costs and say, okay, since the issue has now been settled, we only designate certain costs to be paid to this party and to this party. And that makes, let's say, makes my job a lot easier because it's very simple to do that. But the cash tends to push because settlement is always a much easier way to handle things. And these are the next part is consent awards and costs as well. So this happens when you have again reached an agreement between each other, and we use this consent award to state, okay, the parties have reached an agreement, and the consent award is also legally binding, right? Once we have said that you have reached an agreement, we mention what the agreement is, and once the document is signed, this can be legally enforced and legally binding amongst both parties. And like I said, the costs are decided, and it is a fairly straightforward method. Right. So now I hope you're all awake. I'm sorry if I'm talking a lot, and yeah, we're reaching the end of it, and we shall see after, right? So this is what we have discussed so far. We also have another aspect of the CAS, which is a small part, and it's growing in the CAS right now, which is mediation. You must have all heard about mediation. And this again is a voluntary process, right? Not many, unfortunately, not many parties choose to do mediation, but when they do, you have to choose. It's Mr. Josman and Mr. Dhruv has to choose whether they want to do mediation or not. And then the CAS allocates a mediator to help come to a settlement. It's more, I mean, I would say it's more flexible. It can be handled in much faster pace. It's more cost effective, but still in the sports world, we still find that a lot of people are not choosing mediation because they feel that it's not as effective. But CAS tries to motivate people to choose the mediation guidelines and to try it out, because there are a lot of issues we see that which can be handled in a very straightforward manner. But because of, let's say, different factors, nobody wants to choose it. But I think mediation has a long way to go, and in CAS especially. And yeah, this is how it is being structured. So now we shall see that what are the common mistakes that people do in the CAS. And one, of course, is the deadlines. You miss the deadlines, you are putting yourself in trouble, right? This is one thing where the rules are very clear on it, and you have to try to make sure that you don't miss your deadlines. And if you do have to extend it, just inform well in advance. It's like if you want to skip college, let's say, and I'm not saying please don't skip college, but if you feel like you have to have an excuse ready for it, right? And the same way CAS operates. You have a good excuse, a good reason, then the CAS will grant it. The other is an over-reliance on the narrative. What lawyers tend to do again is that we are storytellers, right? We like to take a subject and build on it and make a story on it and say, no, this is wrong. That was really shambled, and we have handled this in a wrong way. And the CAS, at least the arbitrators, can see through this very well. When they see that you are just over-explaining your case, they know that your case is not strong. So don't panic. Don't have a 40, 50 page document that the judge sees and he's like, oh my God, there's so much to read. Keep it precise, keep it 20, 25 pages, have your points straight, have your formats well. These are the very simple things which again, from personal experience, these are what the arbitrators like to see. Names in neat columns, everything formatted, the same color, the same, you don't end a page with a heading. You make sure if the page is coming to an end and you want to start a new paragraph, you always start with the next page. These are things which makes it easier to read. And honestly, guys, it makes the arbitrator's mood happier. He makes it, he enjoys reading it, right? And that really helps your case. If you do all this, I'm telling you, you have a good chance of, let's say, winning your first case in front of us. The others are, let's say, failing to prepare your witnesses. If your witness comes and says the wrong things, if you haven't taken the time to make sure your witness knows what to say, what not to say, all these are also very important, right? Then you have the de novo thing, which I've explained fairly before, but a lot of parties also fail to understand what really the de novo thing is. Like I said, the CAS has the power to review the whole case again, but it cannot grant whatever it wants. I hope you understand. They can only grant what you have asked for. So that is why your appeal brief, your statement of appeal have to be clear in what you ask. So you have to state exactly what is it that you want the CAS to grant, and only that the CAS has the power to grant. If you say I want 10,000 rupees, but then the CAS later, in the hearing you say no, we have actually felt that we may deserve 20,000 rupees, even though they can, even if the CAS sees and say yes, you know what, you actually do deserve 20,000 rupees, it cannot grant that. It can only grant what you have asked for. So make sure that you have studied the case well and you ask for the things that you know will be granted and not ask for anything extra, right? And yeah, so these are the common mistakes. Just make sure you have, you have given yourself the time, the preparations, right? Know that the subject matter is important. And it takes time, guys. All I'm saying is if you really like to study this, read a lot, understand what's happening in the sports world right now. And I'm sure all of you will do successfully well. And I hope to see all of you all soon one day. And if you have any questions, I think I've given my email at the end, which I will share as well. You can always feel free to reach out. And as a conclusion, these are the few takeaways I hope you could take from this lesson. But you need to understand CAS, final authority, right? There have been discussions recently, if you have read the news, that maybe the CAS shouldn't be the final authority, but as of now it is, and I hope that it does stay the same. The appeals, de novo is something you have to remember. You can have a new, fresh perspective of the case, but you have to make sure you ask what you want exactly. Procedures and deadlines are very important. And the more effective you are, the more chances of you winning your case can be. If you're clean in your arguments, you don't over-explain, you have your formats right, you follow deadlines. Even if you have a weak case, you will get something, right? And yes, I mean, to understand CAS is something that is very essential in international sports law because it is, let's say, the Supreme Court for sport. And I hope you have understood a little bit. I know it might have been a lot of information in 40 minutes or 1 hour, I say. But I hope you've understood something. And again, like I said, if you have any questions, please feel free to email me. And I thank you so much for your attention. Thank you.
Thank you.
Yeah, thank you. Thank you. I hope you can hear me. I hope everything was clear.
Yes, sir.
Yep.
Yes, sir, we can hear you. Okay. Thank you so much, sir, for your truly enlightening and engaging address. Your insights have given us a practical and nuanced understanding of sports dispute resolution, and we have gained immensely from your experience, sir. So before we proceed, I would like to seek your kind permission so that few students could ask very thoughtful questions regarding your session, sir.
All right, I do have to go, but maybe a couple of questions I can
Indeed,
for
sir.
sure.
2 to 3 questions.
Of course.
I invite our students to kindly come up to the podium. I call upon Nayonika from 6th semester BBLLB to take her question.
Good evening, sir.
Hi.
So my question is, based on your experience, what should students focus on to build a strong career in sports law and international arbitration? And is pursuing an LLM necessary? And if so, which specialization would you recommend? And additionally, what alternative career paths in this field should students consider?
Well, yeah, okay. So first off, I would say that students should focus on let's say trying to gain as much as they can in this period, right? I will explain from my aspect. For me, while I was in law school, I I was trying to still think of what I wanted to do, and I was able to take a class like Mr. Joshpin's class on sports law in my university, and I sort of fell in love, right? I really liked what I was learning, and I wanted to learn more. And the only way you can learn more is through a master's, I would say personally, because it not only gives you a taste of what the world shows and what the subject talks about, but also it really helps with networking, getting connected with other people with the same mindset as you. And I think that is very important as well. Because to be very frank, the masters, I might have also been able to learn what I learned in the masters from reading by myself. But the networking, the people I've met, the places I've been able to visit and really interact with professionals who are already working in this field really help. And I think that is very important. And that's why I would say a master's would be something to look into, right? It's I wouldn't say it's completely necessary, but it's something you definitely need to look into, and it will give you a boost as well. And see, I practice again in a very nuanced niche aspect of sports law. You can also be part of law firms who represent clients, because right now me as a CAS ad hoc or as a international sports advocate here, I don't really get to represent clients, which is something I also would like to do eventually. But those are things you could do. You could be a part of a sports law firm in a sense where you do represent clients and do represent them and in front of the CAS or in front of FIFA. You could be part of sports clubs, and let's say Kerala Blasters or Chennai FC have in-house law sports councils who, if there were any disputes, you could handle that. Help with drafting sponsorship agreements or employment contracts for players and different clubs. So there are many aspects of sports law, and you just need to find out what you like, and just keep an open mind. I won't sugarcoat it. It is tough to learn and to put yourself out there. But if you really do like what you want to do, and for me that was very important. I wanted to enjoy what I wanted to do. I wanted to make sure that I don't get bored doing what I want, and just try to find what you like, and then chase that. And I'm sure all of you will do exceptionally well. But as a sports lawyer, if this is something that's interesting, try to read more, stay in touch, and and I wish you the best.
Thank you so much, sir. One last question for the day. I call
Sure.
up Anshul Vinyas from BALLB 6th semester to ask his thoughtful question.
Hello, sir. I had
Hi.
I'm a big football fan, so I had a question regarding football. So
Okay.
currently there is an ongoing dispute between Manchester City regarding the 115 charges, and it's being dealt by the laws prescribed by the Premier League. So my question was, firstly, why these sort of cases take such long timelines to get to a resolution. For example, this case has been going on for 3 years now, if I'm not wrong. And as a Manchester United fan, I would love for them to be penalized. Also, I would like to ask if there is any appellate jurisdiction of CAS in this regard. As in, does the Premier League rules have any appellate jurisdiction in CAS? Thank you.
Well, I would say first off that I'm sorry that you're a Manchester United fan, but no, I'm joking. I'm joking. Uh, but okay. Listen, I think this Manchester City case first off was handled in a very complex manner. It didn't have to be this complex, right? But one thing I think in all legal aspects we need to understand in any jurisdiction, that there is something called statute of limitations, right? Which means that you cannot bring up a case which might or might not have happened 20 years ago and bring it up now, because the charges they're facing is all from 2008, right? It's almost 20 years now. And yes, they were given a fine. And to be honest, there was a part of the case which has already been decided by UEFA, and I can send you the case a little later on. But this was a case where, again, it was about financial fair play, and they had to pay a fine, and the CAS ruled on this, saying that there was not enough evidence to say that all the 120 plus charges were to be accepted, right? And like I said, it will follow Premier League rules. It will follow because the club is an English club, the jurisdiction is English jurisdiction, and it's a FIFA authorized tournament, so FIFA regulations will also apply. When you come to CAS uses these two laws as the applicable law, but also you need to see that there is a statute of limitations to this. Unfortunately or fortunately, I am not a Manchester City fan, but I do love Pep Guardiola, and you need to understand that there there are cases which, if not brought upon during the particular time frame, you have to move on, right? It is the way the world works. And if you see, if you're also following the news, there's Chelsea has also been caught to have violated certain clauses when Todd Boehly, or no, even Ibrahimovic, who was the previous owner, was already up to some things, right? And and yeah, I mean, I'm sorry, Anshul, that you want your rival teams to go down, but I think it might not happen. And as an appellant, as an appeal procedure, this is an appeal procedure, right? If you can, let's say in a situation where Manchester City was fined an X amount, or were fined an X amount, they have the authority to challenge that in CAS. And also, another interesting aspect is in the AFCON final, which is the African Cup of Nations. It was between Morocco and Senegal. I'm not sure if many of you know this, but 4 months ago, in the final, Morocco was conceded a penalty. Senegal won that game, and there was a point where Senegal players had left the pitch. Okay, they had left the pitch because a decision was not taken fairly, and they felt it was not fair, and they left the pitch, and they made a real big issue of it. And for almost 10 to 12 minutes, they were not on the field. But they had two people still on the field calling the players back. They came back, they played the remainder of the game, and Senegal won the AFCON Cup of Nations. What happened then? Then you had a couple of months later, Morocco suddenly wakes up and says, "No, you know what? That was not that was illegal what they did. They couldn't have left the pitch for that long. That is a violation of the rules." And then they filed a case in front of the CONCACAF, that is the Federation of Africa. And Africa as well, they looked at it and said, "Oh, you know what? You're right." And then they revoked the Senegal's victory, and they granted the victory now to Morocco. So what did Senegal do? Senegal now has filed in front of the CAS, and this is still ongoing in front of the CAS. But this is how you do it, right? Even here, I would say that if you do not appeal at the beginning of when you thought this was a mistake, you cannot wait 3 months after everything has been decided and then come out and say, what's done is wrong and we want a redo, right? And now you have a lot of people claiming Maradona's handball in the 1980s World Cup. You have people coming up with ridiculous stuff. So it doesn't make sense, according to me. But if you feel like there is an issue, you'll have to bring it up in a much quicker pace, because these are time-sensitive matters. And yeah, I wish you all the best for your United to let's say find a better coach. But yeah, I hope this has answered a bit of your questions. Yeah. Is that all right? Yeah.
Yeah. Thank you so much, sir, for patiently answering all the questions. And I thank all the students for actively interacting with sir. The interaction had certainly added great value to today's session and has made this discussion even more meaningful. To conclude today's program, I now request our faculty coordinator to propose vote of thanks.
Good evening. Thank you, Gauri. Yes. So firstly, I just would like to extend my heartfelt gratitude to Mr. Thrusita. Although we did not know each other personally, he was kind enough to guide me when I approached him regarding the CAS procedures and this interactive section. Despite his busy schedule, he graciously agreed to conduct this section online. Sir, thank you very much for your time and kindness.
Thank you, Jasmine. Thank you so much for actually inviting me. And yeah, I hope to see you one day. And yeah, I hope you're also doing well. It was nice to put a face to the conversations we were having. Yeah.
Yes, thank you very much again. And I would like to express my sincere thanks to our Chief Executive Suresh sir in his absentia and the Principal ma'am, and student coordinators and all of my sports law students. Yeah, thank you. Thank you, sir. You can leave now, sir. Thank you very much.
Thank you so much, and thank you all again for a wonderful session. And again, I will send you my PPT, Mr. Josman, and you can forward it if you feel like, and if you have my email. So if any student wants to reach out, feel free. And yeah, I wish you all the best. Okay, take care, and see you all soon.
So one thing that you can also share
Yeah.
the answers to those questions if it's
Will
possible.
do.
Yes, sir. Thank you very much.
Will do. Okay, take care.
So yes, we'll take the attendance now and you can leave. Okay.